Judgment 113 宪判 8 Reasoning 1. Standard of review and the constitutional rights involved. The right to life is an inherent right of all human beings. Its existence need not be recognized by a state or be enumerated in the Constitution. It is the supreme constitutional right because a person's life is the precondition for realizing other fundamental rights. It should be protected at the highest level under the Constitution. Nevertheless, such protection is not absolute, as it may be deduced from the designs in our legal system that the harm to a person's life may be justified in a military action by police during law enforcement and self-defense and in defense of others. Furthermore, with the evolution of medical science and societal values, the legal arguments on whether to legalize abortion and voluntary euthanasia also demonstrate that the right to life may be balanced with other rights. The state may punish the offense of homicide for the purpose of just retribution and maintaining social order, so long as the punishment conforms with the principle of non penal sine corpore and the due process of law. In principle, the types of applicable punishment fall under legislative discretion. Nevertheless, as the death penalty is the most severe punishment and irreversible, its application and procedural safeguard from investigation to execution should be reviewed under the strict scrutiny. The scope of review of this judgment is confined to provisions 1 to 4 offenses that the petitioners were involved in, and their accompanying procedural issue. This judgment did not address the constitutionality of the death penalty in general, or laws imposed on other offenses, e.g., treason, drug crimes. 2. The constitutionality of death penalty. 1. Death penalty as the most severe punishment under provisions 1 to 4. The legislative purpose of choosing the death penalty as the most severe punishment for homicide is just retribution and the hope that its deterrence function may reduce crime and maintain social order. Such a function is supported by the sense of justice of the general public. Although the death penalty applicable under provisions 1 to 4 does not serve a specific deterrence function for the imposed inmates, just retribution and deterrence of major life-infringing crimes are still of especially compelling public interest in this country's historical and social context. The death penalty applicable in the cases in question is of constitutional purpose. Death penalty as a punishment under provisions 1 to 4 is a measure that irretrievably deprives the defendant's life and subsequently other rights, which causes significant negative effects in terms of scope and degree. Therefore, the death penalty should only be applied to the most serious types of crimes, i.e., the type and extent of infringement caused by such crimes should be at least equivalent to the defendant's deprived life under the general knowledge at the time of judgment. Only in such a way that the application of death penalty conforms to the constitutional principle of non penal sine corpore. The death penalty as the most severe punishment under provisions 1 to 4 should only be applied to the most serious circumstances and must conform with the strictest requirements of due process in terms of criminal procedure. Within this scope, such a measure can be deemed as a necessary measure to achieve its retributive and deterrence purposes. For a case in question to be the most serious, the mens rea of the intentional homicide found in the case shall be limited to direct intent, general intent, or alternative intent, in which two intents directed to different offenses mutually excluded but equally desired by the offender. Intentional homicide committed under subjective foresight of risk and extreme indifference without a general or undifferentiated intent to cause one or more deaths cannot be considered the most serious. Moreover, meeting the said requirement in mens rea does not necessarily lead to the death penalty under provisions 1 to 4. When determining whether the case has presented the most serious circumstances, the court should consider the motives, purposes, provocations, method used, the damage or hazard caused, degree of breach of duty, and the defendant's relations with the victim, etc. This is to further establish that the defendant's motive and purpose was especially condemnable, ethically and legally, or that the means were especially cruel, and or that the results were seriously destructive and harmful, thus the most serious. Afterward, the court shall consider the defendant's condition when sentencing, whether the defendant is highly prone to recidivism and is impossible to rehabilitate, thus warranted to be excluded permanently by the death penalty. The types of conduct satisfying the constituent elements of intentional homicide under provisions 1 to 4 are vast and complicated. However, distinguishing them on a statutory level may be possible. Relevant authorities are advised to review periodically the differentiations between types of conduct to limit the application of the death penalty and or to develop appropriate alternatives, e.g. a special life sentence with arrest threshold for parole or prolonged imprisonment. 2. Mandatory death penalty for murder during extortionate kidnapping before January 30, 2002. It should be left to the courts to decide whether an individual case involving Provision 5 is of the most serious circumstances, thus warranting the death penalty. However, Provision 5 imposes the mandatory death penalty on the offense of homicide during extortionate kidnapping without taking into account the circumstances. It is obviously draconian and violates the constitutional principle of non pena sine culpa. Within this scope, this provision violates the right to life under the Constitution. 3. Procedural safeguards for sentencing the death penalty on the offenses of the cases in question. 1. The right to be assisted by counsel during investigation. Part 3 of the holding. Mandatory counsel is required for provisions 1 to 4 cases during trial. However, it is not required when suspects in such cases are under prosecutorial or police investigation. In the past, a few wrongfully convicted death penalty cases were later found with multiple procedural flaws during police investigation, which were not identified during the subsequent trial proceedings. In provisions 1 to 4 cases, procedural flaws may be reduced if counsel assisted the suspects during prosecutorial and police investigations. This allows defense counsels to promptly address unfavorable evidence and highlight favorable evidence to the police and the prosecutors, thereby increasing the accuracy of evidence examination and fact-finding. Considering procedural safeguards provided by mandatory counsel in felonies and the above-mentioned problem in practice, suspects of Provision 1 to 4 cases, which are punishable most severely by death, shall have the right to be assisted by counsel during prosecutorial or police investigation. In this way, the suspects may effectively reducing possible miscarriage of justice and uncovering the truth. The COCP violates the right to life, the defendant's right of defense, and the due process of law, insofar as it lacks specific provisions requiring mandatory counsel for Provision 1 to 4 suspects during a criminal investigation. The authorities concerned shall amend the relevant provisions per this judgment within a period of 2 years. If the amendment is overdue, prosecutorial and police investigation shall be conducted per the requirement of judgment. However, the validity of completed investigation shall not be affected.